So I would request you to keep pace with the screen to change the slides from time to time. Is that fine?
Okay, sure, ma'am.
All right.
Hello, everyone present here virtually. I am Ashwin here, and I welcome you all for today's session, which is titled as Protection of Women from Sexual Harassment at Workplace. And presenting this session, we have with us our today's expert, Dr. Gurminder Kaur. Dr. Gurminder Kaur ma'am is an assistant professor, School of Law, Pondicherry University. She is an alumnus of Army Institution of Law in Mohali, from where she completed her BA LLB in 2009. Thereafter, she joined Department of Laws, Punjab University, Chandigarh, from where she pursued LLM in 2001 and was awarded PhD in law in 2019. She has two accomplishment of the national level to her credit. She was awarded the Bharat Scouts and Guides Rashtrapati Puraskar by late Dr. APJ Abdul Kalam. Also, she was amongst all Indian toppers in class 12th in CBSE examination for sociology. So I would like to invite Dr. Gurminder Kaur ma'am. Ma'am, you can start now.
Thank you so much, Ashwini ma'am, for a pleasant introduction. And this is my first association with Research Circle, and I'm very delighted with the way you are bringing different academicians on a platform and connecting us to various audience across the world. And to explain about my work further, I am a human rights person. To say so, I mean that I have always have a bent of mind towards protecting and safeguarding the human rights. Since my childhood, I remember I was a part of adult school also. In my school, when I was studying in class 7 or 8, we were associated with the Rotary Club in Chandigarh, and we used to run a night school for the laborers who were working during the day. You know, the men and women who were not educated. From time to time, our school would make arrangements to take us over there and have interactive sessions with them and try to teach them learning, reading, basic Hindi, Punjabi, whatever was their mother tongue. So I belong to the state of Punjab, and before I joined here in Pondicherry University, I was appointed by the UPSC, and I was working in Dr. Ambedkar Government Law College here in Pondicherry, which is a legendary institution in its own right. And for my doctorate, I worked on the rights of women prisoners in the state of Punjab. For that, I visited for about 13 jails where they have kept women prisoners at that point of time. And I examined more than 600 women. That is just to share my opinionated ideology that there are certain sections of our society that have been targeted and made vulnerable just because of certain identical characteristics that they have since their birth. For instance, caste or poverty or gender. So these types of vulnerable groups have always been, struggling to be treated with equity, to treated equally, and to be respected in the society despite of any odds. In India, after our independence, even before our independence, we had social thinkers and activists who were working for the women. But the Constitution of India brought in the idea of equality between men and women, and it took this desire one step further by providing protective discrimination in favor of women, right? So I'm not sure if most of you are from the background of law, but the today's topic that I have selected as my first interaction through the research circle is protection of women from sexual harassment at workplace. And my concentration will be only on the law which is prevalent in India. Before I start discussing about the law, what protects, who is protected, who can be made liable under the act, and what is the procedure for the complaint, and what are the bodies that have to carry out the investigation of a complaint. What happens if a person is found to be the culprit of having committed an act under this, or what happens if a woman is found to have given a false evidence. All these possibilities are covered under the act, which we will be discussing over a course of 80 to 90 minutes during our lecture today. But the background of this law is rooted in a judgment of 1997. That is a very famous case of Vishakha versus state of Rajasthan. There a very unfortunate event happened, which ultimately went up to the Supreme Court, whereby Supreme Court gave a very strong judgment to protect women at their workplaces. To share the facts of the Vishakha case, there was a NGO in Rajasthan that used to work to prevent child marriages. So there was one worker, she prevented a child marriage in Rajasthan, in a small place in Rajasthan. The marriage was stopped, but later on, the family of the so-called groom and the bride, they came together, some male members, and in order to threaten her and give her a full lesson of what had she had done, which they believed to have been a derogation of their customary practice of child marriage. So she was raped and in her workplace, that is her NGO. So from there, the rape complaint gained the momentum, and it reached, by the time it reached the Supreme Court gave very strict guidelines of protecting women at their workplace. Now, this fact that I have shared with you is an example of only one very, very serious act in which the sexual dignity of a woman is compromised. But we all have noticed at from time to time, and unfortunately, if I talk to women here, there have been or there may have been instances where they have been subjected to some behavior at any public place, whether it was their workplace or a market or a road for that matter. At least at once in their life, they might have experienced any male member going and trying to touch them, trying passed some lewd remarks or made some facial or gestures with their hands, which were not acceptable. So when such things are taking place in an open environment, on a road, in a market, even religious places are not safe from these. Then when this situation gets more complicated, when the woman is a working woman. Ideologically, throughout the globe, women are the front runners on the domestic front. It was very difficult for the men folk to acknowledge that women were working and to accept a working woman and to help them have a work-life balance. Forget about work-life balance. Even today, women are looked at just like a commodity for physical satisfaction of men at so many levels that, you know, categorizing them that illiterate people treat them like that or literate people, no. Any kind of genre of background can be there. It depends upon an individual to individual, what is the extent and depth of respect that they have for the women folk. To protect such women who were working in different fields, whether as a domestic worker or a construction laborer or a banker, a teacher, a scientist, or you are a, you know, victim, you are a patient in a hospital and you are admitted in a hospital, or you visit a hospital, or you are a customer in a bank and you're going to the bank, or you are a student and you're studying in a school or a university. Anywhere where women are present in a public light, there needs to be a system of protecting them. There is no need to say or declare that. But unfortunately, in our country, that had to be done. How it was done is now what we will proceed with. Madam, please change the slide. Yes. So when was the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013 passed? This is the very first law in India that was passed. Now, the judgment that I was referring to was in 1997. Looked at how long it took for the government to come up with a law which finally put these things in black and white. This law came to, it was passed on 22nd April 2013. Very soon, after about 12 or 13 days from now, we will be completing how many years of its passing? 9 years. This was in 2013 and now is 2022. And the rules with regard to this were passed on 9th of December 2013. What are the objectives of this act? To protect women against sexual harassment at workplace, to prevent sexual harassment of women at workplace, and to redress the complaints which arise because of sexual harassment of women at workplace. Please, the next one, madam. Most importantly, you will have to understand few definitions. First is what amounts to sexual harassment. Second is what is workplace. These two definitions are the life breath of this law. The judgment in Vishakha versus State of Rajasthan has explained the problem of sexual harassment very clearly. But the definition of workplace is something which took a very long time for the parliament to come. Earlier in 2010 also, one bill was passed to protect women from sexual harassment at workplace, but that bill was not it was not passed. It was introduced, but it wasn't passed because the definition of that bill, the definition of the term workplace in that bill did not cover domestic workers. Under the 2013 Act, it is amply clear that even domestic workers will be protected under this Act. I will tell you how. First of all, which kind of behavior amounts to sexual harassment? For this, we will have to refer to two sections in the Act. First is Section 2N. It defines sexual harassment and it says it includes any one or more of the following unwelcome acts or behavior. Unwelcome acts or behavior. I will have a discussion with you about welcome acts and unwelcome acts little later, maybe after half an hour or so. After I complete my PPT, I will also be discussing about 2 or 3 highlights of the act, which are actually posing a great challenge in today's scenario, especially in India. First one is very, very obvious: physical contact or advances, or demand or request for sexual favors, or making sexually colored remarks, or showing pornography, or any other unwelcome physical, verbal, non-verbal conduct of sexual nature. This is exactly what I was trying to tell you when I said that women have at some point of time either witnessed or unfortunately experienced some kind of this kind of behavior even while walking on an open road. The next one, ma'am. Section 3, subsection 2 further elaborates that if any of the following circumstances occur or is present in relation to or connected with any act or behavior of sexual harassment amongst other circumstances, it will amount to sexual harassment. First, under section 2N, general things were written. Here, contextual exchange of idea or communication is what is being referred to. Please pay attention. Applied or explicit promise of preferential treatment in her employment. Example, you befriend with me, you go to a vacation with me, and I promise to give you this promotion. Unfortunately, this practice is believed to be prevalent in the private sector. There have been very remarkable complaints regarding this type of behavior from the corporate sector also. This is one point where I will be discussing with you welcome and unwelcome behavior. Let me finish with this definition first. Second, implied or explicit threat of detrimental treatment in her employment. First one, they're saying preferential treatment, that I will give you a promotion. Second one, they're threatening. If you do not come with me, if you do not agree to do this type of act with me, then I will demote you. I will put a complaint against you. I will see how you will succeed. These types of threatening sentences or behaviors, explicit means very clear, direct, and implied means indirectly. Through your behavior or by grouping with other people, you are doing this to the woman worker. Third, implied or explicit threat about her present or future employment status. I will throw you out of the job if you will not coordinate with me for what I'm asking you to do right now. So now you read the ideas in 2N along with these statements. Any physical contact with an implied or explicit threat about her present or future employment status, right? Showing pornography and asking her to enjoy it with the perpetrator with either a promise of preferential treatment or a threat of detrimental treatment. So these types of things, because an action with an idea must have some end result also in their mind. This is the end result. That is the action which will make you culpable. This is the end result which you have to prove, not that it happens, but this is the state of mind of the person who is doing that action which is given in 2N. Please look at point number 4. Interference with her work or creating an intimidating or offensive or hostile work environment for her. In my observation, as a researcher, as a student, as a teacher, I have seen that this is the most common shade of sexual harassment at workplace visible in India in public sector. Creating a hostile work environment. If a woman raises her voice against something that has happened to her and she's not happy about it, people stop cooperating with her. People just stop talking to her. Sometimes they feel, oh, I don't know what will she understand out of my statement. I will maintain my distance. Oh, I don't know what is going to be happening. Sometimes people may be true, sometimes they may be false also, right? And last, humiliating treatment likely to affect her health or safety. This goes like really far away, and it is an obvious bad thing for which actually evidence will be easily available. In all these other 4 things, proving the evidence or getting the evidence itself becomes a problem. Now, I told you that I will explain the point of unwelcome behavior. One small example I will give you. In TV shows or in movies, in whichever language, mostly we see that love affairs happen between co-workers, right? Love affairs happen between co-workers. Co-workers means people who are working in the same organization. They can be of the same standard, right? Managers, assistant managers, junior staff, multitasking staff, anything, or they may be senior or junior to each other. Irrespective of the gender, they may be involved with each other. They get into a love affair, they become physically proximate, right? After they break up, if they break up, and after they break up, the lady feels, and maybe both of them are angry, but the lady feels, okay, I will use this law as a weapon against this man. He is now not dating me. So she starts to give proof of those interactions and physical associations that they had with each other at the time when they were dating, when they were in love with each other, and it was known to the public. So that type of interaction is a welcome interaction. There may have been any of these promises, but when the woman is getting involved with the man with her own choice, then there is no accusation which will sustain with regard to sexual harassment at workplace. The foremost point that has to be proved without any doubt is any behavior which is culpable under this act must have been unwelcome behavior. The woman does not want to deal with any man for that matter like that. This Mr. A, who is trying to pursue Miss B with regard to this, is something that Miss B does not want. Right? Next slide, please. Now, we have seen there are two parties at least. There must be an aggrieved woman, and then there must be a respondent, a man against whom the complaint is being made. So first of all, who is an aggrieved woman according to the Act? Section 2A defines the aggrieved woman. First, now here you will see the relevance of domestic workers. I was telling you the definition was not including domestic workers earlier in 2010 law. Under 2013 law, it is including. Let's see what it is. In relation to a workplace, a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent. I will repeat again. In relation to a workplace, a woman of any age, little girl, old woman, middle-aged woman, young lady, anyone, whether employed or not, means a woman who is visiting that complex also in any capacity, if she is subjected to behavior like that, she can pursue for a complaint like this. I gave you the example. In a bank, if I'm a customer. In a hospital, if I'm a patient. Right? In a school, in a college, if I'm a student. I'm not employed there if I'm a student. Employment is for the teachers and the other staff. But here, if I am employed and I'm working, then I am definitely protected. But other than that also, any establishment in which there are workmen and a woman is present on those premises and any act with regard to sexual harassment takes place, this law is applicable. Second point is of far-reaching importance, especially in Indian context. In relation to a dwelling place or a house, dwelling place means where people live, apartments, in a slum area, lots and lots of small sections where people are living together, a house, a building, right? A hotel for that matter. A woman of any age who is employed in such a dwelling or house. Please pay attention. A woman of any age who is employed in such a dwelling or house. That means in places of private life. Only when somebody employed visits and then this act takes place, it becomes a workplace for them at that point of time. The difference in these two clauses is, in the first one, which is a workplace, whether you are an employee or not, you will be protected. But if you are in a dwelling place, present in a dwelling place in the capacity of being an employee, then what is going to happen? You will be protected under this act. If you are a woman in your own house and you are raped, then Sexual Harassment at Workplace Act will not be relevant. Other provisions of law will be relevant. Rape is covered under IPC, that will be relevant. Moving to next. Now, in the first definition, they're talking, madam, please, the previous slide only, the next clause I wanted to discuss. Yes, thank you. What is the meaning of a respondent? Respondent means a person against whom the aggrieved woman has made a complaint. Section 2M of the Act defines this. Respondent means a person against whom the aggrieved woman has made a complaint. Okay, that's simple. Madam, the next one, please. What is workplace? This is very, very extremely important. Section 20, look at how much of detail they have covered. Any department, organization, undertaking, establishment, enterprise, institution, office, branch or unit which is established, owned, controlled, either directly or indirectly by appropriate government or local authority of a government company or a corporation or a cooperative society. So this clause covers all the establishments which are owned or run by the government either directly or indirectly. government schools, government colleges, government companies, government banks, government cooperative societies, all those. Then coming to the private sector, even government hospitals will be covered in the first clause itself. Coming to private sector, organizations or a private venture, undertaking, enterprise, institution, all these things, right, which are carrying commercial, professional, vocational, educational, entertainmental, industrial, health services, or financial activities, including production, supply, distribution, or service. So anything under the umbrella, under the sun, is covered by this clause in which the private sector is running them. Then the third, they are significantly clearing hospital or nursing home, private, public, public or private partnership, NGO, anything. Hospital or nursing home is also a workplace under this act. Fourth, again, specific mention. Any sports institute, stadium, sports complex or competition or games venue also. If you have a basketball tournament in your college, there is some youth fest going on and your institution is hosting any one of the games, maybe carom board game or badminton or basketball. So that is just one venue for one event. And if unfortunately something goes wrong here, that will be a relevant workplace under this act. Next, any place visited by employee arising out of or during the course of employment, including transportation provided by the employer for undertaking such journey. This point is covering two things. First, any transport facility which is given to you by your employer, irrespective whether the employer is government or private. So any service which is given to you in terms of transport by your employer, and if any event like that of sexual harassment occurs on this transport, a bus, a van, an auto, a car, right, or a two-wheeler for that matter, these days even Ola helicopters are available, whatever is being provided by the employer. Unfortunately, if anything takes place of that objectionable kind on this transport, then also that will be protected. Second thing which this clause is clarifying is that any place visited by the employee arising out of or during the course of employment. For example, I am a teacher in the university. My university tells me that, madam, you have to go to so-and-so college to conduct vivas for this course of students on this date. I go to that place because my office has asked me to do that. My employer has asked me to do that. If God forbid something happens to me when I'm going to the other place where I have to carry out the vivas, then also I will be protected under this act. This is what this means. And the last point, which I have already discussed with you, a dwelling or a house. Dwelling, better example of a dwelling will be hotels, guest houses, these holiday homes which people run in their own homes. If I have a large house or even a small house, but I need to make some money, I give one bedroom and one washroom to visitors. If I'm living in a tourist place, I will provide them with a gentle homemade breakfast, and according to that, I will be taking charges from them. God forbids, if anybody, if my servant or a maid or support staff who is working with me to take care of that establishment also, she experiences something of objectionable nature which is defined within sexual harassment at workplace, then even she will be protected. Please move to the next one. Who is an employee and who is an employer? Now, these are little complicated things, not very complicated actually. I will be telling you, this employee includes any person who is employed at the workplace, either on a regular, temporary, ad hoc or daily basis, or directly or through an agent, whether they are working for a remuneration or not, they are working on voluntary basis, they are there on contract, they are there on internship, they are there on probation, anything which brings them in contact with the employer. A woman who is going to any establishment to carry out any official work is considered as an employee. It does not mean, it does not discriminate that whether a woman is a vice president of a company, or she is a clerical staff member, or she is a sweeper. No. A woman in an establishment which is defined as a workplace under this act is protected as an employee. Employer, again, this is with regard to workplace. All government establishments, all private establishments, hospitals, stadiums, managers, co-workers, right? Appropriate government or local bodies, then the management of companies, all these are included within the term employer. The term employer is not targeting any person in particular. This is to prove who has administrative control of that establishment at that time when the impugned act is committed. Please go ahead. Next, please. Yes. What are the duties of employer? These are very simple. The duties of employer are, first, a general duty to maintain a safe environment and to ensure that no such event of sexual harassment arises. Then he has to mention in a visible, dominantly visible format in his workplace what are the consequences if an internal complaint committee takes an adverse action, decides that the complaint was true and the respondent needs to be punished. What will be the punishments? Who are the members of ICC? If it is not covered under ICC, local complaint committee will be there. Who are the members of that? What will be the consequence? General things with regard to honoring the dignity of women must be there at conspicuous, that is visible, dominantly visible spots in the employment establishment. That's what these duties are about. Please, the next one. What is the definition of unorganized sector and who is a domestic worker? These are two most challenging areas, and these are two still untouched areas where women are still suffering from this harassment. Most of them don't even know that they have protection of law, and those who know do not have the resources, courage, or even basic level of literacy to defend their own honor. It is heartbreaking, but it is true. Let us see what is the expression unorganized sector about. Section 2P defines unorganized sector in relation to a workplace as an enterprise owned by individuals or self-employed workers and engaged in a production or sale of goods or providing service of any kind whatsoever, and where the enterprise employs workers, the number of such workers is less than 10. Very, very simple. There is a small beauty parlor in your locality. There is a small tailor shop. There is a small grocery store. There is a laundry unit, right? Or there is some property dealing consultant in your locality with 4 or 5. Any of these establishments with, 4, 5, 6, 7 members. Any beauty parlor will not have more. Small beauty parlor in a small locality will not have more than 3 or 4 ladies working. At the max, they will have one gentleman to take care of the gents' haircut. That's all. Tailor, one major male man and other assisting, mostly ladies. Things like this. Now, this is unorganized sector, which is not covered under any government establishment or private establishment. No, this is an unorganized sector, which is not registered anywhere. A small tuition center for that matter. Maths tuition, sir. Science tuition, sir. Physics tuition, sir. English tuition, sir. Right? If any students are going to a particular man to study after school hours in that man's house or in a commercial building also, then that will also be covered under this act. If any unfortunate event takes place, then that will also be safeguarded. Then comes domestic worker. Domestic worker generally means the maids and the servants who are helping in our homes or in any other establishment to carry out the basic jobs of cleaning, washing the utensils, or even cooking of food, taking care of small children or aged persons, right? Gardening, uh, ironing the clothes. That's what, right? Let us see. According to 2E, domestic worker means a woman who is employed to do household work in any household for a remuneration, whether in cash or kind, either directly or through any agency, on a temporary, permanent, part-time or full-time basis, but it does not include any family member of the employer. No. If there is a young mother and an old grandmother in the house, and they take help from a girl who is 20, 21 years old to take care of the small child or the old grandmother, or to help them in the kitchen, only this girl who is 20, 21 years old will be considered to be a domestic worker. Right? Next one, please. Now, what is an internal complaints committee? Now, before we go to this, we have to understand that in any organization or any workplace, if unfortunately any event or a complaint of sexual harassment happens, where will this victim, that is the aggrieved woman, where is she going to raise her voice? There are two possibilities where she will raise her voice. If her workplace has more than 10 members, then every such workplace has to have an internal complaints committee. I will tell you about the composition and working of these internal complaint committee. But generally, any aggrieved woman has to complain. Where first category, if her workplace has more than 10 members, then it must have an ICC. If her workplace does not have 10 members, less than 10 members, then at every district level, there should be a local complaints committee in which the district magistrate will be the head of that committee. He will be the senior most member of that committee, and they will be taking care of this. Fine. Now, starting with internal complaint committee. Every employer of a workplace shall constitute by an order in writing a committee to be known as the internal complaint committee as per section 4 subsection 1. Where should this be located? It should be located at all workplaces. Where the office or administrative units of the workplace are located at different places or division or subdivisional level, the internal complaint committee shall be located at all administrative units or offices. I will give you an example from my own experience. I was working in a government college before I joined this university. In my government college, we had internal complaint committee. I was one of the members of that internal complaint committee. Now, why am I giving you this example? This second point, which we are talking about, location of ICC. Now, all government colleges in Puducherry are under the supervision and control of Directorate of Higher and Technical Education. So when they are here as the administrating superior body, even they have an ICC at their office level. All these colleges become their administrative units at different locations. So all these locations are also required to have their own ICC. Please, next. Who are the members of ICC? First will be presiding officer. There will be only one, a woman employed at a senior level in the workplace from amongst the employees. In case a senior level woman employee is not available, the presiding officer shall be nominated from other offices or administrative units of the workplace. For example, if in college A, the five senior most people are male members only. So for the purpose of this ICC, they can depute a senior member from college B to be a part of this ICC. other than the presiding officer, there will be minimum 2 members who will be employees committed to the cause of women, or who have expertise in social work or have legal knowledge. So there is a choice between 3. Out of these 3 categories, minimum 2 members should be appointed. One from amongst the employees, or both of them should be amongst the employees, or other than that, you can go for a social worker or with someone who has some legal knowledge. They are called. Then next one member from amongst NGO or association committed to cause of women, or a person familiar with the issues relating to sexual harassment. They are called external members. They are called external members, usually advocates with a good background in the society for protection of women, or some social workers, or some students, or even some media houses for that matter, train and become these type of members. I'm also undergoing such training, and hopefully soon I will be certified to be one. And total, whatever is the maximum number of the membership, 50% of this internal complaint committee, minimum 50% should be female members, should be ladies. That must be the attempt. Next one, ma'am. What is the tenure of the members? They shall hold office for a period not exceeding 3 years from the date of nomination as a member. Are they paid any money? Only those members will be paid who are members from NGO or association, and members, people who are internal members, they will not be paid any money, right? That external member only will be paid. Next. Now, this district officer will become relevant because of local complaints committee. I told you that for organizations where less than 10 members were working, in that organization, what is going to happen? If any such unfortunate event takes place, the woman wants to make a complaint. But ICC will be there only when there are more than 10 members, 10 or more members. Less than that, there will be a universal standard body. Anybody from anywhere can go. For instance, any domestic worker, anybody who was working in the unorganized sector, those ladies, if they get affected under this law, they will go to the local complaints committee. Before we discuss that, there are some definitions which we should see. Who is a district officer? District magistrate or additional district magistrate or collector or deputy collector may be notified as district officer for every district. What are their duties and powers? As per section 20, this district officer shall monitor the timely submission of reports by the LCC. LCC is short form for Local Complaint Committee, and take such measures as may be necessary for engaging non-government organizations for creating awareness on sexual harassment and the rights of women. Next, please. What is Local Complaint Committee? It is in a district, a committee known as LCC has to be constituted. The district officer shall constitute the local complaint committee in a district. It is to receive complaints of sexual harassment from establishments where ICC has not been constituted due to having less than 10 workers, or if the complaint is against the employer himself. Now, this is the second instance where LCC will have jurisdiction. For instance, this woman who wants to make a complaint, she is complaining against the senior most, the boss of the organization. So when she knows that it is against the boss, then theoretically, we want to protect the interest of the woman. Boss, being in a bossy position, may be able to influence other members of the internal complaint committee. So that matter should not be decided by that organization. It should be decided by somebody outside that organization. Who will have power outside the organization? The LCC. They will be taking care of this. What is the jurisdiction of LCC? Jurisdiction means area of control. The jurisdiction of LCC is extended to areas of district where it is constituted. Districts, I believe you understand, the parts of a state are divided into district according to their territorial nature. Cities and towns and villages are grouped together under one district. A group of districts makes a division, and a clubbing of division makes a state. Please, next one. Who are the members in local complaint committee? Like in ICC, I told you there will be one presiding officer, then other 3 members. Now here we are talking about a chairperson, one eminent woman in the field of social work or committed to the cause of women. One member nominated amongst the women working in the block, taluk, tehsil, ward or municipality of the district. 2 members nominated from amongst NGO or organization committed to the cause of women or a person familiar with issues relating to sexual harassment. Who is going to be constituting this? The district officer. At least one of the 2 members shall be women. At least one of the 2 shall have a background in law or legal knowledge. At least one of the 2 shall be a woman belonging to scheduled caste or scheduled tribe or other backward classes or a minority community. Member ex officio, the concerned officer dealing with social welfare or women and child development in the district. So these are all the members, and their term of office is also the same, that is 3 years, just like that of the ICC. Next, please. How will a complaint be filed? Now we come to the more procedural part of it. Somebody alleges, a woman alleges that some misbehavior has happened with her and she wants to deal with that man with full seriousness. So she makes a complaint. How, when, within how much time she will be required to make the complaint? This is what we'll be talking about now. Then we will be discussing what will be the action of the ICC or the LCC on that complaint. Likewise, we will go ahead. Now let us take some time to discuss how will a complaint be made. Any aggrieved woman may make in writing only a written complaint of sexual harassment at workplace to the internal complaint committee or the LCC within 3 months from the date of incident or the date of last incident if it is a series of incidents, right? Some women are very proactive. At once a man will misbehave, they will raise their voice. Some women don't want to play with fire. They say, okay, he's just barking, let him bark like that. I will ignore him. Once it happens, 10 times it happens, 20th time when it happens, she loses her patience. So in that case, within 3 months from the last incident, if it was a series of incidents. In case women who cannot write, the presiding officer or any member of ICC or the chairperson or any member of the LCC will render them reasonable assistance so that their complaint can be converted into writing. Simple case you take, domestic workers. These construction workers, laborers, you know, the women who lift those taslas on their head and they are just transferring little bit of the mortar that is mixed up with the cement that is being made, and that is going to be fixing the bricks in the wall, right? So what do these women know? I was teaching them when I was in class 7th and 8th. I was 13, 14 years old, 12, 13 years old. And they had no idea. They did not even know how to hold a pen, a pencil for that matter. They couldn't even identify which was the correct side of a notebook, whether to open it like this or to open it like this. So that standard of population we have, and we want to protect them from these types of misdemeanors because they deserve to be protected. That is why it is a duty of all the members of the ICC or the LCC to render whatever support is possible to help them. Then, very, very important, what will be the action of ICC or LCC on the report of committee, on the receipt of the complaint? There are 3 options. First option, once this receipt is there, they must proceed to make an inquiry in accordance with the service rules which are applicable to the respondent, and where there are no service rules, in accordance with the rules framed under this act. Second, they can directly forward the complaint to the police, right? What is to be done when both the parties are employees? That is one example which I was giving, that they are co-workers in whichever capacity, senior, junior, same scale, no problem. Where both the parties are employees, the parties during the course of inquiry will be given an opportunity of being heard, and a copy of the findings will be made available to both the parties, enabling them to make a representation against the findings before the committee. Somebody raises a complaint against Mr. A. Mr. A naturally should be given a chance to explain his side of the story also. And the complainant, Ms. B, should also be present before this committee to tell verbally, explain in much greater detail what her grievance is. Next one, please. What is the power of ICC or LCC? This means when a complaint is made, investigation or inquiry is made, what ultimately can they do? For the purpose of inquiry, they shall have the same powers of a civil court under CPC 1908 to summon and enforce attendance, that is to call somebody to be present before them, to require the discovery and production of documents, any proof they want to give, like screenshots they want to give, they want to show a video or an audio recording, any other matter for which may be prescribed. When will the complaint be forwarded to police? It is a very serious matter. Let's see. They can forward a complaint to the police for registering a case under section 509. That means for criminal intimidation and any other relevant provisions of IPC within 7 days. In the event of non-compliance by the respondent of the terms and conditions, a settlement agreed upon, and when the aggrieved woman informs the ICC or LCC about it, then they make an inquiry and forward the complaint to the police. Sometimes what happens, the woman raises a complaint, there is some conciliation that takes place inside her organization, and then she says, okay, if he apologizes in public and if he refrains to misbehave with me in future, fine, I will close the matter here. So all this, if it has to be forwarded to the police, all this detail must also be forwarded to the police. What is the time limit for the woman to go and inform or to raise her voice against a complaint? We have already discussed. Within 3 months, she has to do it. Next, please. Can this time of 3 months be extended? Yes, if it is found satisfactory that there were such circumstances under which she could not come. Very serious case, for example, happens where the woman is assaulted. Somebody is trying to pull her closer to his body, and she is trying to, avoid him. She is resisting this attempt, and in that she gets seriously injured. She goes to a hospital. She is found fractured. She takes some time to recover, and after she is on her feet, then she wants to file a written complaint to her employer. All other legal matters in crime in police will take care, but she also wants to try him at the workplace. But by this time, her treatment is okay. More than 3 months have passed. What is she going to do? She is going to request, along with all the proofs, to this ICC or LCC and telling them that I was unable to come before this 3 months deadline. So kindly allow me a little more time. At the most, with maximum within 6 months, this matter has to be reported. Second thing, in a similar situation, rational question arises, can somebody else file a complaint under this act? Now, this woman who is seriously injured lying on a hospital bed, can her family members, her well-wisher, can they file a written complaint regarding sexual harassment? That is yes. But it can be done only by her legal heirs or such other person as may be prescribed to do so. Generally, it is the husband or children, or if she is unmarried, then parents or brother or sister. No friends, they cannot take care of it. Next. What is the scope or process of conciliation and settlement? I just told you that here, sometimes the woman herself says that this man is bothering me again and again. I am here to inform you, but if you wish to counsel him and make sure that he doesn't bother me again, I will not take this matter further. This results in conciliation. Ultimately, if it may be agreed, both the parties may be asked to write down that we have no problem with each other. The culprit may be asked to declare an apology, and he must be asked to sign on a commitment that he will not repeat again. But this settlement in no case can have any monetary settlement in it. No. Counseling can result in verbal settlement, which is to be proved by the behavior which follows after that, but not in terms of money. Second question is, if the settlement is arrived at, still can an inquiry be made? Answer is no. No further inquiry is ordinarily to be made. However, if the aggrieved woman says that even after settlement, this man is still bothering me, then the inquiry can be made. Next slide. What is the time limit of inquiry? Now, this inquiry, when it starts, the complaint is to be made within 3 months. Similarly, the inquiry has to be completed within a period of 90 days, right? Second question, what can ICC or LCC recommend to the employer during the pendency of an inquiry? What does the employer do on such recommendation? During the pendency of the inquiry, the LCC or ICC, on written request of aggrieved woman, can recommend the following things to the employer. First, transfer the aggrieved woman or the respondent to any other workplace. Grant leave to the aggrieved woman up to a period of 3 months. Grant such other relief to aggrieved woman as may be prescribed. Leave granted under this section is in addition to the leaves which she is otherwise entitled to. This is a compulsory leave for her. This should not be deducted from her personal leave ledger. Last, the employer shall implement the recommendations which are made by the ICC or LCC and send the report of such implementation to the ICC, right? If ICC says you transfer the respondent to another college for the time being, they have to transfer him, and then it has to be reported to the ICC that the transfer has been made. Next, please. What is to be done by ICC or LCC on the completion of inquiry? On completion of this inquiry, they will provide a report of findings to the employer or the district officer within 10 days from the date of completion of the inquiry, and this report will be made available to the concerned parties, right? What will be the components of this report? Some recommendations have to be made. Here we are having 3 options. First, if the complaint committee arrives at the conclusion that allegation against the respondent has not been proved, it will recommend to the employer or the district officer that no action should be taken. Option 2. If the conclusion is that the allegations against the respondent are proved, it will recommend any of the following. But to take action for sexual harassment as a misconduct and in accordance with the previous provisions of the service rules applicable to the respondent, or where no such service rules have been made in such a manner which are prescribed here. Third, to deduct from the salary or the wages of the respondent a sum which is to be paid to the aggrieved woman or her legal heirs. This is as a compensation, not as a settlement. 4, in case the employer is unable to make any final deductions, he is not able to conclude what to do, or from the salary, the respondent being absent or he resigns from the service during this time, then the ICC or LCC may direct the respondent to pay the woman, the aggrieved woman, such charges directly from his pocket. In case a respondent fails to pay the sum, then accordingly the arrears can be added to the payment, and ultimately the payment will be taken from the land revenues of the concerned district officer. Next one. If they arrive at a conclusion that the allegations against the respondent were malicious, that is, they were false, made with wrong intention, or the aggrieved woman or any other person making the complaint has made a complaint knowing that it was false, right? Or they have produced any forged or misleading document, then now instead of the respondent, the aggrieved woman is the one who should be taken to task, right? That I will just tell you right now. Now they are saying, what is the time limit for the employer or the district officer to act on the recommendation? Maximum within 60 days. All those previous things which I have told you in option 2 and option 3, they have to be carried out by the relevant authority within 60 days. Next. This I have marked in red because it is a red alert that you should not take this law lightly. Any law which is made for the protection of any group of individuals, whether it is gender protection or caste-based protection, or it is protection for anybody in a particular situation, any misuse makes it impossible for the genuine victims to get justice. My fight is for those people because they need justice. They need the state to support them. But such individuals who keep on filing false complaints knowingly just to have sadistic pleasure that I will show you the true colors of my hatred towards you, and I will take you to the jail and to the courts, and now you see how I will make your life hell. This type of attitude puts a lot of pressure on the courts and the justice delivery system, because it is not written on anybody's face or forehead whether they are nice people, they are truthful, or they are fallacious. This will be found out only after due inquiry and following the due process of law. And it takes a lot of time, money, effort, and human resources to figure that out. These days, more and more complaints are found to be false, especially with regard to matrimonial disputes, which are of criminal nature. Complaints under Domestic Violence Act, maximum of them are found to be false. So, what is the apprehension in the mind of the courts and even the police institutions which are there to protect the women? At the beginning, subconsciously, they feel, oh, it must be false. So instead of offering an olive branch to the real victim or making the system slightly smoother and more conducive to the needs of the victim, the system looks even at the victim with the same eyes as it looks at the accused. Either one of them can be the accused. If it is a false accusation, then obviously the accused is going to be punished. If it is a case, if it is a true accusation, then that will happen. If it is a false accusation, then the woman is the one who will be punished. So generally, it becomes more difficult for the real victims to seek justice. That is why I have highlighted these items in red, that if any woman knowingly, like earlier I gave you the example that boy and girl started dating in the workplace, and later on the girl, after the breakup, said, I will show you my true colors and all that nonsense, and she goes and files. And it is found that she has given a misleading and a false complaint. Now what will happen to her? If the ICC or LCC arrives at a conclusion that the allegation against the respondent is malicious or the aggrieved woman has done this, then they will recommend to the employer or the district officer to take an action against the woman or the person who has made the complaint in accordance with the provisions of the service rules. Usually in government service, there will be dismissal from service as the final decision. In between that, there will be suspension. Right? If the ICC or LCC arrives at a conclusion that during the inquiry, any witness has given a false evidence, not that the complainant was false, no, but there has been some type of misuse of power either by the complainant or by the respondent, and some witness has given a false evidence or produced any forged or misleading document, then it may recommend to the employer of the witness or the district officer to take action according to service rules. Next one, please. Can the ICC or LCC recommend compensation of payment of an amount to the aggrieved woman? If yes, then who will pay and on what basis and how? We have seen that money can be paid as compensation. The answer is yes, right? They are to deduct them from the salary or wages of the respondent. As such, the sum to be paid to the aggrieved woman or to her legal heirs. In case the employer is unable to make these deductions from the salary of the respondent due to him being absent or cessation of employment, the ICC or LCC will direct the respondent to pay this sum to the aggrieved woman directly. In case this direct payment fails, then they will forward an order of recovery as an arrear of land revenue to the district officer. As per section 15, the basis of determining the sum to be paid to the aggrieved woman will be: first, mental trauma, pain, suffering, and emotional distress caused to the aggrieved woman; loss in career incurred by the victim for physical and psychiatric treatment; income and financial status of the respondent; and feasibility of such payment in lump sum or installments. Usually, in cases of compensation arising out of crime, all these four parameters are kept in mind. So this is what. Next one, please. I believe this is the last slide. Okay. What are the provisions for appeal? Now we are saying that the ICC or LCC will make these orders and then they will be carried out, right? But a person aggrieved due to the following conditions may prefer an appeal to the court or a tribunal, or in such a manner as the Act provides. Recommendation under 13.2, that if the ICC or LCC arrives at the conclusion that the allegation against the respondent has not been proved, it will recommend to the employer to take no action which is required. If they find the recommendations have these complaint has been proved, it will recommend to the employer and the district officer the following: to take action against sexual harassment as a misconduct. This we have already discussed, right? Then recommendation under 14, that is, in case they find out that the complaint was malicious or false. And recommendation under section 17, if any person contravenes the provision of section 16 of the Act, they shall be liable to pay a penalty with the provisions of service rules applicable. The point is, two questions arise. 3, can appeal be filed? Answer is yes. Where will the appeal be filed? In the High Court. Third, within how much time the appeal has to be filed? Within 90 days from the receipt of the recommendations of the ICC or the LCC. Next slide, please. Now, what is the penalty for non-compliance with the provisions of this Act? What are the provisions of this Act? Two fundamental provisions. First, constitution of internal complaint committee, and second, constitution of LCC. Okay. If it is found that either one of them was not existing at a time when any woman who was harassed at her workplace sexually, she needed to make a complaint and there was no body to which the complaint was to be made, then these provisions will come into power. What? Punishment with fine up to 50,000 can be done on an employer if there is no ICC as per subsection 1 of section 4, or if the employer has not taken any action under 13, 14 or 22, or if the employer has contravened or attempted to contravene the provisions of this Act. This is the most obvious shortcoming. Second, twice of this punishment is liable if any employer, after having been previously convicted for this offense, again repeatedly does this. That, for example, in 2018, there was an instance of sexual harassment and it was found that no ICC has been constituted. Later on in 2021, again, complaint against the sexual harassment arises. Again, it is found that still no ICC has been constituted, that the same punishment or amount of fine will be doubled. Then there can be cancellation of license or withdrawal or non-renewal or approval or cancellation of registration by the government or the local body if the employer has been previously convicted of any offense punishable under this Act. This is a procedural matter. Then when will the court take cognizance of this offense? Now, till now we are talking about mechanisms which are working only about the organization. Court has still not come to the power, only in case of appeal. Now we are talking about the court. The court will take cognizance of the offense on a complaint made by an aggrieved woman or any other person authorized by ICC or LCC. No court inferior to that of a metropolitan magistrate or a judicial magistrate of first class will try any offense punishable under this Act. Minimum is CJI or an MM, that is a metropolitan magistrate in a metropolitan city. Metropolitan city is the one which has a population of more than 1 million and has been notified in the official gazette of the concerned state to be a metropolitan city. So in these situations, the court will take notice. What is the meaning of word cognizance? When will a court take notice of this problem? It will be in this situation only. Next one, please. Yeah, that's all. So I have shared with you, madam, you can stop sharing the presentation now. Thank you so much for your cooperation. It was very well timed. As I have stated to you throughout this presentation in a very super fast speed, actually, I have tried to tell you what amounts to sexual harassment, where can sexual harassment take place, if it takes place, who can make a complaint to whom, once a complaint is made, what is to be done, what kind of final result we can have. Ultimately, can the police or the court be involved? Whatever the questions arise, I have given you the answers. 3 complex situations arise under this act. I have already mentioned about 2. I will repeat them once again. And then third is a very recent development. I will talk about it also. I probably in another 10 minutes, we may be winding up the session as well. First, as I told you, with regard to unorganized sector and domestic workers. Any act which amounts to sexual harassment under this law otherwise is also an offense under IPC, right? Outraging the modesty of a woman, sexual harassment otherwise under IPC, voyeurism, pornography, all these items are there under IPC as well. Now, it is a choice of that aggrieved woman. Generally, when this type of behavior happens and she feels enraged, she is angry that how dare anybody behave like that with me, she will go to the police. The prevalence of this law does not disentitle her from going to the police. She will, she can, she should go to the police. What is the relevance of this act over here is that when male members who are in a position of employment or a co-workmanship, they are not supposed to take liberty with their female co-workers, that their presence is not for the entertainment of the male members. A woman who is working may be wearing any kind of clothes. In India, we rarely have a problem with regard to dressing, especially in public sector. But in private sector also, some people make it an excuse. Oh, she's very modern. She's always dressed in a Western wear. This cheapness in your brain and in your conscience is not entitling you to disentitle another woman from her position, her power, her capacity, and her entitlement of work. So when a situation like this arises, in any case, a direct police complaint is there, but the woman feels like being capable of raising her voice in her workplace also, so as to disentitle this man and to stop him from behaving like this with anybody else in future. This is one point. Second point is inability of domestic workers or members of unorganized sector to still get justice under this act. The problem here is lack of sensitization. Lack of sensitization. Anything in India happens, no? Man, woman, young, old, third gender, anything. If you have a problem, people will say, don't get involved with police, be tolerant, ignore it. Or at the most, they will threaten the culprit directly and they will say, you stay away, you don't repeat it again. And that's the end of it. Rarely do people take this on their shoulders to fight. We have had some cases in which members have fought and they have led to remarkable judicial decisions, like in the case of Vishakha. There is another case of there was this nurse, she was raped, and she was raped so horribly. Aruna Shanbag's case I'm talking about. She was raped so horribly that she was left on a ventilator for more than 1 decade. Her friend, who was another nurse, She was the one taking care of her during her treatment. And where did she get raped that horribly? At her workplace only, by another this one compounder type of a man, these male nurses. He was the one who had raped her. And there was another second lady friend, the third person dominant in this dispute, that she was taking care of her. Ultimately, this case became famous for euthanasia, mercy killing, that if a person is left in a vegetative state for such a long period of time, they lose the essence of being a human being. Therefore, it should be lawful for their well-wishers or guardians to declare them as dead. But the problem in this case also arose from sexual harassment at workplace only. Then third situation, which is not related, which is also about a workplace violation, was the Jessica Lal murder case. That girl was a model. She was working as a bartender in a party at one night, and then this murderer accused, rather now a convict, he's been in jail for quite a long time now. He was there to enjoy the party. He demanded a drink from the girl said the drinks counter is closed. Within 1 second he took out his pistol and shot the girl right here in the forehead, and she dropped dead. This became a very famous case because to fight for justice for her, along with her family, it was a news reporter who kept on getting vigil regarding this case and followed the trial through and through and created so much pressure on judiciary not to favor this accused, because accused belonged to a very powerful political family. This was based in New Delhi, this case. These three cases come to my mind. They don't seem to be connected to harassment of women at workplace, but the roots of the dispute lies in this fact only. Except for Vishakha, the other two seem to be different because of the final outcome of the judgments. But the beginning point of the problem is abuse of women at their workplace only because they are a gender which is propagated as a gender for sexual pleasures of the opposite sex, right? So this ability that the God has given them to reproduce is being used to abuse them. So this law is available as an addition to the other criminal laws. This is one point. Second point is with regard to unwanted and wanted behavior. Unwanted and wanted, which I discussed at the very beginning. If you are being physically close to a man, you yourself as a woman are greedy of getting some position which you don't deserve, but you know that if I will be frank and physical with him, he will give me a favor. You do that, and later on you realize he just used you for his enjoyment, and then you cannot. Rather, you can, but you will be proved to have done it in an improper manner, and then technically you should not be raising your voice against this, because this is not an injustice. It is a case of bad choice for you. The third thing, which was a recent development, came from a very recent judgment of the Kerala High Court, by which they have directed all the film industry unions to create internal complaint committee in order to take care of sexual abuse of women at workplace cases in that industry. The major argument given by the government and the body was also that the film industry does not have a relationship of employer and employee. All of these people are there in terms of service for contractual relations, right? The court said, anyhow, either you hold the ear like this or you hold it from the other side. There are women who are working with men, there are men who are working with women, and somebody is working for somebody else. Therefore, similar to that, there must be an appreciation of this law, and internal complaints committee must be constituted in the film industry as well. This was my way of enlightening the audience regarding this law's prevalence, existence, mechanism, and also some dicey areas in which there are problems. With this, I conclude my lecture, and that's all. In case there are any questions from the audience, I would be very happy to take them.
Thank you so much, ma'am. It was a very informative. I believe it was a very different topic that we have experienced till date, because mostly here the research related topics and like it's an actual it was a lively topic, I must say, because everyone is working somewhere and everyone is
Yes.
employed and
Either a
everyone is
student or an
employed.
employee. Yes, sir. Yes, sir.
So as well, the Miss Ashwini has left because her office time is till 5 a.m.
Okay. Okay.
5 p.m. So I will be the Thanksgiving. So let me tell you that all the participants who were live from Facebook and YouTube, you if you have watched from somewhere in the middle, or if you want to share this, this complete session is available on our Research Circle YouTube channel. I
Okay.
must appeal all the participants that you please share to all the fellow workers or all the fellow relatives, to anyone, to everyone. I must say this session. And if you have any queries, you can just type in the comment box, which
Yes,
will be
yes, yes,
available there.
yes.
We'll try to give the answer by Dr. Gurminder. So. Yeah, lastly, I would like to thank Dr. Rubinder for taking out the time. It was a very informative session, and I also, as I'm here the employee as well, so I also come to know many things, because as a male person, you also need to know that these things
Yes,
that
yes, yes, yes.
sometimes it might be a misunderstanding. So you must clear that out, and you must
Yes.
work
This
very.
this law is actually a very balanced approach for both the genders, rather,
Exactly.
because very few laws they have declared that any woman raising a voice which is proved to be false, she will be taken to task. But in this one, they have given a very cautious sword already. That is why I made that slide in red letters itself. That this is not to be played with. It is not for your entertainment. That okay, you were flirting with me yesterday and today you are not dating me, I will take you to task. No nonsense happening. Somewhere women are losing their lives because they were raped and they were on in a vegetation state for more than 17 years, and look at what you are doing with it. So with that
Exactly.
approach, it is more useful rather for the male members to identify their limits of exchange of information and behavior with their co-workers. I believe that is
Exactly.
more important.
Exactly, ma'am. We got the point, and every male will be watching this session. Will somehow came to know that these are their limitations. So it was a very, I must say, it was a very informative session, and thanks for that.
Thank you.
So,
Thank you
with
very
your
much.
permission, I would like to conclude your session, because
Sure,
questions will
sure.
be coming after the people will be watching this.
No problem. No
So,
problem.
so you can just directly comment in the description box as well.
Definitely, definitely.
Thanks, ma'am. Have a
Thank you
good
so
time.
much. It was very nice to be associated with you. I hope we may have another informative session soon. Thank you
Absolutely,
very much.
absolutely. Yeah, thank you,
Thank you
ma'am.
so much.
Have a good time.